you don't give a rat's behind about this case. You have taken off 4 different times.
I wanted to come in today.
The only reason you're here today is because I ordered you here
Yes,
today.
sir.
It's a rhetorical question. You don't have to.
Welcome to Judge Talk Zone, where accountability meets consequences. Today we're diving into a courtroom session that pulls no punches. A judge pushed to the limit by defendants who repeatedly skip court, ignore orders, and test the system's patience. From pleas after 4 no-shows, to bond violations with 0 compliance, to a case that's been dragging on for over 1,200 days, yes. You heard that right, over 3 years. This is what happens when excuses run out and the judge says, enough is enough.
Yes, I saw that you guys had. Oh, Maple.
Yes, Your Honor.
You as well, Judge. Thank you.
Take care. Or you want to do the plea now?
Yes, Your Honor.
I'm ready when you are. Joshua Maple, come up. Mr. Maple, you're charged with 2 cases. You're charged with driving while intoxicated. You're also charged with unlawful carrying of a weapon. You guys have worked out an agreement where they're going to dismiss the unlawful carrying of a weapon in exchange for your plea on the DWI. You need to understand that this DWI will go on your record. It's going to be there for the rest of your life. It's even there after you die. It's important because if you ever get pulled over, an officer is going to look at your record. They're going to see a DWI. What do you think they're going to do to you if they smell alcohol or dope? Right. What we're doing today, from now on, you are facing a minimum of 30 days in jail. No more slaps on the wrist. Do you understand? So if I were you, I would never get in a car, even if you've had a sip of alcohol, a toke off a joint, whatever it may be, because you're taking a humongous risk. For $20, you click one button, you can have a car taking you perhaps $30. Anywhere you want to go, it's a geographical oddity why it's always $25 to $30 with Uber. Do you understand? Giving up the right to a trial, right to compel witnesses to on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, there's no turning back. It's a lifetime decision. Is this what you want to do? Yes or no?
Yes, sir.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Yes, sir.
I will find you guilty, sentence you to the 3 days in jail, give you credit for the 1. There is a surcharge that you will be required to pay for this case.
I want to put on some testimony concerning the surcharge.
Okay.
Mr. Maple, where are you currently employed?
With my uncle. Working with him.
What do you do?
Look at houses, remodel them, and fix up houses.
How much do you generally make a month?
1,500.
Okay. Yeah, but I take it you have to pay for somewhere to live, correct?
Yeah.
You have to pay for a vehicle, insurance, cell phone, food.
Yes.
When your monthly bills and expenses are paid, does it pretty much equal what you make, the $1,500 you make each month? Can you speak up?
Yes.
And would you be unable to pay a $3,000 surcharge based on your financial situation?
No.
Past witness.
Why on earth would we bend over backwards to help you when you don't give a rat's behind about this case? You have taken off 4 different times. You have failed to appear in this court for court settings. Why on earth have you taken off 4 times? What? So you just don't care about us and work is more important than court, huh? Actions speak louder than words, Mr. Maple, but you have taken off 4 different times. You are lucky that you are not in jail right now as it is. So why on earth would we help you when you don't even want to help yourself? Why?
Just trying to better myself. I should have listened to my gut and come here.
How much do you really make a month, Mr. Maple?
1,500 a month.
Who do you live with?
My dad,
Who are you here with now?
just the lawyer.
I don't know. You know, it's
Young kid, nope. Working, not a troublemaker, just.
here's my problem, Mr. Maple. My problem is that you've taken off on us over and over and over and over. Today, you're walking out of here and nothing is happening to you. My experience is that when we are too easy on people, they don't get the message and they act like a bonehead out there in the free world. And then they end up either picking up a new DWI or doing something else that's even worse. How do I know that you've learned anything about this? Because like I said, with how bad you've acted with us over the course of the last 7 months, you're skating out of here with a proverbial slap on the wrist. How do I know that you have learned anything, Mr. Maple?
Because I got my baby brother looking over me, and I gotta do better.
Here's what we're going to do. I will take off the $3,000 surcharge, but you will be required to pay the court costs in this case, for which are around $500. And I'm going to tell you now, if you don't pay it, every $100 you owe, you will sit in jail for 1 day. So you will be required to pay for something. And if you don't pay it, your butt will sit in jail for almost a week. Do you understand?
Yes, sir.
And I'm going to tell you now, the next time you come back, if you come back with the DWI, it's around $6,000 in surcharges, not to mention court costs. So you can look forward to around $7,000 in fines and fees. If you want to drink, if you want to get loaded, if you want to smoke, find another way. Do you understand? Because if you come back, it will be HE double hockey sticks to pay. Do you understand?
Yes, sir.
I'm suspending your license for 180 days. You are not allowed to drive at all. If you drive, that in and of itself is a Class B misdemeanor, just like.
Alright, let's break down what just happened with Joshua Maple, because this case is a perfect example of judicial frustration meets measured mercy. Maple failed to appear in court 4 times over 7 months. That's not a scheduling conflict, that's a pattern of disrespect for the legal process. And here's the judge's dilemma. How do you hold someone accountable without destroying their life? Especially when they're clearly struggling financially. The judge had every right to revoke Maple's bond and send him straight to jail. Instead, she waived the $3,000 DWI surcharge, a huge financial break, but made it crystal clear. This is your last chance.
A DWI, a driving on a suspended license case. Heed this warning. There won't be another one. Do you understand? All right.
Your Honor, any previous suspension from this incident, would it run concurrent?
Really? Really? No. No. There has to be some kind of consequence, man. Really? Taking off 4 times? I'm taking off 3,000 now. And he wants me to. I love you. Go. So 180 and then just the court costs.
I'm here on Emma Lynch. She's got a bond violation. You wanted to talk to her.
Okay, do you mind bringing her up?
Yes, Miss Lynch. When we were here last time, you ordered her to have the interlock installed on her vehicle. She is not driving the vehicle. It's not drivable. We just need to switch her to a portable
Oh, no.
and a no driver.
She has nothing. And it doesn't matter. We ordered you to have an interlock in a car. You haven't done anything and you're without any kind of devices whatsoever, right?
That was totaled, and it's at my house right now. But I don't have I'm in a rental car.
Emma Lynch's case is a textbook example of what not to do when you're out on bond. When a judge orders you to install an ignition interlock device in your vehicle, that's not a suggestion, it's a court order. And here's the thing. Lynch's excuse was, my car was totaled, I don't have a vehicle to put it in. Sounds reasonable, right? Wrong, because the solution is simple. You come back to court and say, Judge, I don't have a vehicle. Can we switch me to a portable breathalyzer instead? That's what probation officers are there for. That's what the system allows. But Lynch didn't do that. She went completely off the grid, no device, no monitoring, no check-ins with probation. From the court's perspective, that's a huge red flag. The judge's response? Bond set at $5,000, and if she doesn't comply by Monday, she's going to jail. Here's the lesson. Courts will work with you if you communicate and make an effort. But when you disappear and ignore orders, you leave the judge no choice but to assume you're a flight risk or a danger to public safety. This case shows why bond conditions exist. They're not punishment, they're safeguards. And when you violate them, you're telling the court, I don't respect this process.
Car that I'm not driving, so I don't have a car to put it in.
So you have no device.
That's correct.
You're not being monitored.
That's correct.
This is not a good thing, Ms. Lynch, because I ordered you to have a device. And from what I understand here, you never even went and got it.
Just because she doesn't have a vehicle to put it on.
But you come back and you say, hey, Judge, I don't have a vehicle. I need to do something else. You just don't, out of sight, out of mind. That's not the way things work.
Judge, for that violation as well, we instructed her in court and sent a message for her to report to 49 following court to get further instruction over everything so that we could figure out things from there, and she never reported.
Stephen. Ms. Lynch, you haven't done anything. They've literally bent over backwards to help you and do stuff, and you haven't done anything.
I wanted to come in today.
The only reason you're here today is because I ordered you here
Yes,
today.
sir. Yes, sir.
She goes with you.
Yes, sir.
Emailed, texted, call, nothing, you know?
I understand. Would you consider setting her a new bond? Or do
Of
you-
course, 5,001. And then, you know, if she's unable to, then what's today, Friday, Monday, then we can talk. Okay?
It makes me start.
Yes, ma'am. Thanks. Okay. Corey.
Judge,
Hey, good morning.
got Mr. Adams, Derek Adams.
Okay.
It's
a really old case.
yes,
I've told him it's time to put this baby to bed.
yes.
Is there an offer in this case?
No,
How come after 1,258 days, there is no offer?
1,258 days. That's 3.4 years that Derek Haddon's case has been pending. Let that sink in. And here's the kicker. The judge just ordered an ankle monitor on Adams immediately, and she's paying for it herself normally. That costs $400 to $500 per month. That's the court literally bending over backwards to help him. Adams' attorney tried to argue, Judge, he's been through hard times. He lost his sister. He's working at a Chinese restaurant now. He has 3 kids to support. And the judge's response? I have sympathy for hard times, but your repeated failure to appear is a constant kick in the ding-ding to us. Let's be clear about what's happening here. Adam's bond should be $10,003 based on standard court guidelines for repeat failures to appear. But it's only $1,002, that's 92% lower than it should be. So when the attorney asked the judge to skip the ankle monitor requirement, her answer was simple. At 1,258 days? Hell no. This is judicial patience finally running out. The judge gave Adams 2 weeks. Accept the plea bargain or go to trial. No more delays, no more excuses. And if he skips court again? The bond goes astronomical. In her words, here's what we learn from this. The legal system will give you chances, but at some point, accountability matters. 3.4 years of delays isn't bad luck, it's a choice.
I'm hoping we can get a gun safety class and dismiss.
It appears that was
Come up, Mr. Adams.
The delay is probably due to the missing dash cam that's still outstanding that we do not have.
I don't care.
Yes, Judge.
Get on it now.
Yes, Judge. Well,
Why on earth would we allow you to do this class where you get to dismiss this case when it's 1,258 days and you've repeatedly taken off? It's a rhetorical question. You don't have to answer it. But I'm telling you now, I'm giving you 2 weeks to decide what to do with this case. The next time you come here, you will either accept a plea bargain agreement or I'm setting your case for trial. Do you understand? Not only that, I'm putting an ankle monitor on your ankle now so I know where you are at all times. Do you understand, Mr. Adams? And the next time you take off, I'm going to make your bond so high you're going to have teeth falling out. Do you understand?
Judge, if I may, my client, shortly after this arrest, he lost his mother, and I believe it's the mother of one of his children.
No, my sister.
Sister. He fell on hard times. He was already, not well employed, and he's been through some rough times in his life in the past few years. He recently got a job working at a Chinese restaurant, and he has 3 children that he helps take care of. I'm not exactly sure when his last failure to appear was. It might have only been 1, but he hasn't been in trouble since this arrest, I think in 2021, right? So I asked the court to withhold from, giving him an ankle monitor. The state's also missing evidence here. If we can come back. And
Last time we saw him was 3 years ago, Corey. So, I have sympathy in the fact that everybody has hard times, but your failure to appear on a repeated basis is a constant kick in the ding ding to us, and I'm not going to take it. And I'm going to tell you now, I don't know why your bond is not at 10,003, because that is what it really should be. Your bond is at 1,002, and it's way off of what it normally would be. Because I'm telling you, your bond should be 10,003 because that's what they're normally set with a person who has absconded as many times as you do now. You're lucky that you're not in custody as it is now. Do you understand? But at 1,258 days, I don't trust you. And so the only way I know that I'm going to keep tabs on you is with an ankle monitor. And like I said, the next time you take off, and it doesn't matter what the excuse is, the bond is going to go astronomical. Do you understand, Corey? I'm sorry, but if it were maybe 500, maybe 300, I would relent on not putting a monitor. But at 4 years or however long this case is, hell no.
I think that reflects his law abidingness, right? That he hasn't been in trouble, had any interactions with the police.
How do I know that?
Well, yes.
I don't know.
He hasn't been. He would have been in an orange jumpsuit, I guess. If he
Not
had to.
necessarily. I mean, we don't know how he's been out of county, out of state. Look, you're walking out of here now. You're getting 2 weeks to decide what to do. You're not going into custody now. So you're still walking out of here, but I'm putting a monitor on you. And I'm telling you something else that I should make you pay for it, where it would cost you around $400 to $500 a month, but I'm going to eat it. So there's no excuse. Do you understand, Ms. Adams? But you got to understand that in court, we hold people accountable. You may be able to live your life like this outside of the free world, but not in court. We will hold you accountable. And the next time, get ready. Take a seat. Of course. Hey, expedite it, whatever you need to do to get that.
And that's a wrap on today's session of accountability in action. We witnessed 3 cases that perfectly illustrate what happens when defendants test the court's patience. Joshua Maple got a financial break but a harsh warning after 4 no-shows. Emma Lynch faces jail time if she doesn't comply with monitoring by Monday. And Derek Adams, after 3.4 years of delays, he's now wearing an ankle monitor courtesy of a judge who's done playing games. Here's the bigger picture. These cases show that judges walk a tightrope between mercy and accountability, between helping people and protecting the community. They want to give second chances, but those chances come with conditions. And when you ignore those conditions, consequences escalate fast. Today's key takeaway: communication and compliance are everything. If you're struggling, if you can't meet a court order, tell the court. They'll work with you. But when you disappear, ignore orders and show up with excuses, you're forcing the judge's hand. So, what did you think? Were these judges too harsh, too lenient, or just right? Which case shocked you the most? Drop your opinions in the comments. We read every single one. If you learned something today, smash that like button, share this video with anyone interested in the legal system, and don't forget to subscribe to Judge Talk Zone for more real courtroom content, legal education, and cases where justice meets accountability. Hit that notification bell so you never miss a session. Until next time, this is Judge Talk Zone, where the truth speaks louder than excuses.